Hi everyone, this is Dan Grunfeld for Judicate West, Results Beyond Dispute, Profiles in Excellence. For those of you who are regular listeners, you know that I usually do not do an extensive preamble to our guests. This, however, is a special episode. When my colleagues and I created the concept of this podcast and its focus on individuals who excel in what they do, I made a list of 15 individuals who I wanted to invite as guests to the show. And on that very first list was Jake Deere, who I have known for many years. So I reached out to Jake and invited him onto the show. And as was typical of Jake, he resisted because he did not believe that his accomplishments were sufficiently excellent. After another discussion or two, he agreed to appear. And then we started to try to figure out the date when the show would be taped. And then Jake reached out to me again to advise me that he had been diagnosed with stage 4 cancer and did not have much time left. I, of course, was horrified and deeply distressed, and I assumed that any appearance on a podcast was off the table. After all, he had many, many more important things to deal with. And then Jake reached out once again and said that after talking to his wife Mo and others, he would like to appear as a guest on a podcast. So we chatted and came up with 3 things that would make this show different than any other Judicate West Profiles in Excellence episode in the past or the future. The first was that both Jake and I are longtime supporters, contributors, and members of the board of the California Supreme Court Historical Society. And after talking to the current leadership of that fine board, we agreed that this episode would also be co-sponsored by both Judicate West and the California Supreme Court Historical Society. And this interview would be part of their oral history program. Jake is the first non-California Supreme Court justice to be honored with an oral history. Second, unlike any other episode, there were no time limits to the length of the show. We would go as long as Jake wanted to or his stamina would permit him. And third, I asked him whether he wanted for me to put on the table his very serious illness. What he ultimately told me was that the answer was yes, but he didn't want to start with that, but rather to first focus on his life and what he had seen and what he had learned. And as you will see, that's exactly what we did. Jake passed 8 days after we taped this episode. And Jake, who got so many things right throughout his life, got one thing wrong. He absolutely epitomized excellence. His accomplishments speak for themselves. His legacy is magnificent and secure. He improved every friendship and institution he chose to grace. He will be sorely missed. Rest in peace, Jake Deere. You know, if you were going to take out your phone and use your favorite search engine on the topic, national importance of the California Supreme Court, what will come back to you is something along these lines. The California Supreme Court is widely regarded as the most influential state high court in the nation. Because of California's massive economy and legal landscape, the court's rulings on civil rights, employment, and technology frequently serve as blueprints for federal courts and legislatures across the country. The court often addresses emerging complex legal questions years before federal courts and other states do. That's what will come back. Now, of course, the credit or the blame, depending on how you like the decision or don't like the decision or like the court or don't like the court, goes primarily, as it should, to the justices of the Supreme Court. But any court, and especially a Supreme Court, is much more than its justices. And today, we have the honor of talking to one of the most important, respected, and influential non-justices in the last 40 years of the California Supreme Court, Mr. Jake Deere. Beginning in 1983, Jake has worked at the California Supreme Court for more than 4 decades as first Chambers Attorney for respectively Justices Stanley Mosk, and then Joseph Grodin, and then Chief Justice Malcolm Lucas, and then as a Chief of Staff for the most recent former Chief Justices, Ron George and Tani Cantil-Sakauye. Jake is also a longtime editor of the California Supreme Court Historical Society Biannual Review. Jake, welcome.
Very happy to be here, Dan.
I want us to go back and explore the path that got you here. But before we do that, I want to start our chat with this. There's a phrase that many people who have worked with you or collaborated with you over the years have heard you say over and over, the law is my client. What do you mean by that?
What I mean by that, and as I've mentioned to annuals who come into the court and I give a court history tour, it's an intellectually luxurious position to be at the court and to be in a position where you read the briefs on both sides, but your job is to present to your justice the most objective view of how this should evolve. And literally, it's luxurious not to have a client who wants to fit a square peg into a round hole and make things turn out a certain way, but instead to let the law and precedent and the structure of a statute, et cetera, be your guide and lead you to what you try to present as the most objectively natural resolution of a legal question.
And in the 40 years you've been in the Supreme Court, have you ever had a justice either expressly or implicitly say, actually, I am your client?
No, I think maybe a few of the other justices kind of here and there, some of the justices might have balked somewhat at a staff attorney presenting to the judge and say, I'm putting the law and my allegiance to the law over my allegiance to you. That's a possibility, and I think some justices work close to the edge on that. But almost all of the justices, when you come down to it, almost all of the justices, certainly all that I've worked for, and almost every other justice on the court that I can think of, really appreciated their staff attorneys giving them the most objective advice that they could expect, and speaking truth to power in that way, and testing them for that reason. So I think that's really been the overriding theme of, by far, most of the justices.
Let's go to the beginning. Anybody who's walked into your office in the Supreme Court will have seen the wooden shoes that you have from your childhood in Europe. You spent part of your childhood there. How did you get there? What were your parents doing there? And what impact do you think it had on your future path?
I still happen to have them in my office.
This was completely unplanned, audience.
That's my 9-year-old self wearing these shoes and putting the wear on it. Yeah, my father worked for General Electric, helping to design nuclear reactors, containment vessels, hopefully correctly, and we were transferred to near Arnhem in the Netherlands in 1966. I wore these wooden shoes out of our house, which is on the edge of a forest. It was really kind of an idyllic situation. I look back at it now, and I ask myself, was that a movie? That was really quite something. These were fields that with haystacks that Van Gogh or Monet could have painted, and here we were with my sisters traipsing about in these fields in these wooden shoes.
Well, as you know a little about my childhood, it was partly spent in Ethiopia and partly in Philadelphia. I would not have done well wearing those shoes in my particular childhood, just a different part of the world. What happened next? In other words, when did you first consider
the law or public service is something that was under consideration of how you wanted to spend your life?
It was probably in high school. The Nixon administration was imploding. I was fascinated by the Watergate hearings, Senator Sam Ervin, etc. I had a house painting business at the time. I was painting neighborhood houses, but I had a little portable radio, and I would listen to the live Watergate proceedings as my partner and I were painting houses. And I think probably at that time, the idea of being a lawyer and going into law probably crept into my consciousness.
So were you channeling the great Dutch masters that you saw in your youth into the house paint jobs that you were doing, or?
No, this was quite pedestrian work. This was not fancy. This was not artistic painting. This. I do paint though on the side. I painted oil paints mostly, quite a bit in my younger years, but that unfortunately ended. By the time I got to law school, I had less time to paint.
I'm always struck by folks of this generation, how many of them were impacted by the Watergate hearings. I have a very good friend who decided that she wanted to become a journalist because of Watergate and the work done by the Washington Post, and you and other lawyers who wanted to get into it. It's for some members of our generation, it was sort of a seminal event in how we viewed the world.
Yeah, it was an awakening for me, and to see the testimony and the drama behind the scenes, but the lawyers laying things out in a methodical way. I was very impressed with all of that, and that probably triggered a lot of interest in the law for me, I think.
And law school was where?
UC Davis. I was an undergraduate at UC Davis for 4 years. Took a semester off in the middle. That really worried my parents. They thought I was going to quit or something, but no, I just needed a break. We were painting houses in apartment complexes the whole time as well. I worked my way through undergraduate and law school by painting houses in apartment complexes. But then another 3 years at the law school. It was one of the main law schools I wanted to attend. I was also accepted way back at Wisconsin. That I would have had a whole different career trajectory if that had occurred.
Yeah, maybe not. Do you think you would have come back to California had you gone to Wisconsin?
Who knows? There's forks in the road in a person's life. Just looking forward a little bit, we'll talk maybe about my clerking for Justice Mosk, but I was in the position of 4th out of 3 slots for a position for Chief Judge of the Ninth Circuit, and I didn't get that position. If I had, another fork in the road, I think my career would have been extremely different. I would not have ended up at the California Supreme Court, and who knows where I would have been, but yeah.
It clearly did not impede the future success that we're talking about today. Going to law school was, I dare say, the second most important thing that happened to you during that time framework, right? Isn't that when you met your wife to be?
Frankly, she saved me in corporations. We were the professor was asking me questions about the Ringling Brothers Barnum and Bailey Circus closed corporation dissolution case. And he stayed with me for, it felt 5 minutes at least. It must have been at least that long. And finally, this lovely young woman who I'd quite intentionally sat next to raised her hand and saved me further embarrassment. Kind of an unusual thing. You don't normally raise your hand in law school, but she did. We went out for coffee and donuts at the silo afterwards, and the rest is history.
Yeah.
And
all those years later, you still owe her, right?
Yeah.
All these years later.
And I joke with her now and with family members and friends, whenever people have super practical questions about the law, I say, she's the one to talk to, not me.
At some point, I think right after law school, you ended up working at the Yolo County District Attorney, correct?
I did, yes.
There was a case that became famous, the Danny Tita case, where you played a major role. Can you, on behalf of all Dannys, can you tell us that story?
So I was an intern investigator, and they sent me out to do snooping around and investigation and writing up reports and such, and also serving subpoenas. But and that was obviously for local projects and such. But in came a letter one day from a woman in Akron, Ohio, and she was basically saying to the DA's office, "My son has been convicted of killing a police officer here in Akron. He's innocent. He was in California at the time, but he's been convicted. Can you please help me out?" That was the genesis of the case. Of course, the lead investigator at the DA's office was not interested in investing their official resources into this, so he handed it off to me. I took it on, and it was a fascinating experience. I snooped around and went to numerous motels and spots in West Sacramento, where I had leads from the letter about where he was, and managed to document that he had indeed been in West Sacramento. There were some really telltale and quite individual elements to his personality. He was known by his friends to go into a store and steal a big steak, Chateaubriand and such, and stuff it down the front of his pants. Well, people tend to remember people like that. But I also found hotel ledgers that showed where he'd been and so on and so forth, and documenting that time. And a few years later, investigators came out. I think it was on habeas corpus by that time. And I toured them around and showed them all of these documents and so on and so forth. And he was eventually freed. And that was a learning experience for me. I mean, the system had convicted erroneously, it turns out, but the system ultimately corrected.
And how did you eventually get to the California Supreme Court from there?
Well, I was a student at Davis. I undertook an externship with Justice Mosk over the summer of 1982, actually. It was fascinating. They had a policy of actually not hiring annual law clerks who had been externs. And I knew that going in. So I thought, well, I'll enjoy the externship, even though I won't be able to apply for an annual clerkship. But fortunately, they made an exception for me and encouraged me to apply, and I did. And this was at about the same time that I was also mentioning earlier the fork in the road story about how I was also in the running for a position for a spot on the chambers of the head of the Ninth Circuit. So glad that it turned out the way it did.
You know, the exception probably was a reflection of your skill set and your promise.
It might have been a reflection of something.
Yeah.
Do
you remember your first day walking in to the California Supreme Court?
Generally, I think yes. You know, it was kind of an awesome experience. One had the feeling going through these double doors on the fourth floor and entering the justices' chambers area, which is really quite separate from the public area of the court. One had the feeling of entering, you know, hallowed ground, holy of holies, things like that. It was a fabulous feeling then, and frankly, I never lost it. Over 4+ decades, I never lost that feeling.
Do you think, and for what it's worth, and you know, I've mentioned it to you in a past conversation that we had. To this day, when I walk into a court, I haven't lost it either, and I've been to, you know, thousands of days in court, not nearly as many as you have, but that awe of walking into a court and being in a place that's somehow bigger than all of us is, to me, incredibly powerful. And I was wondering whether the fact that so many hearings are now being done via Zoom, do you think that potentially has an impact on the majesty of the law or how the public and lawyers feel about the profession?
Yeah. Yes. I think it has an impact, and I doubt it's a good one. In a number of ways. I used to compare the California Supreme Court, again, I'm talking about the Ninth Circuit, to the Ninth Circuit. The Ninth Circuit is a satellite court. Judges are spread all around the West Coast. So is staff. There's a headquarters in San Francisco, but people are only sporadically there over the course of the year. And I used to contrast that model with the California Supreme Court, which was a model where basically everybody was in the building. The Southern California justices moved up to Northern California or got apartments up here. And all of the staff was in the building, and there was exchange and interchange in the hallways and throughout the course of the day. And leading up to the pandemic, that had already started to change quite a bit, but the pandemic was the nail in that. The court is now very much a satellite court, just like the Ninth Circuit, with justices based in San Diego, LA, and San Francisco, and staff spread out the same way. And so the exchanges, the spontaneity, that happens in conversations where you don't even plan on talking about a specific issue or specific case, but it just comes up naturally. Those kinds of things are lost. And I think that's also reflected in Zoom oral arguments. I think a lot of the human and elements of exchange are lost in our newer environment. I think it's unfortunate.
What do you think the implications are of this loss on the development of the law?
Well, so much of the work of appellate court law is done way in the background, on computers and in one's office and working things out. And so, in a way, it's tempting to say, that's where the work of appellate courts is, and the open exchanges that you see in the courtroom at oral argument and such. The absence of a robust system like we had previously is not going to affect things too much, but it does on the edges.
Yeah, I think that stands to reason. Going back to your days with Justice Mosk, who is a legendary figure, how did working for him shape your approach to legal research, writing, collaboration, and otherwise sort of influence you through the decades that followed?
I was influenced primarily, although Justice Mosk was fabulous, and I had some lovely exchanges with him, and he danced with my wife at our wedding and such. But my greatest influence on that staff was through his chief of staff, Peter Belton, who was in a wheelchair. He'd come out from Harvard Law School in the late 50s to work for the court, and ended up eventually working for Mosk when he came on. Peter was a brilliant writer. He taught me how to write. I thought when I showed up there that I was a pretty good writer. Peter showed me otherwise, and drilled into me many of the quirks and hopefully some of the good things that I maintain today, and I've tried to pass on to others. Also working with him was a fabulous woman named Olga Murray. Olga did a number of Mosk, wrote a number of Mosk's major cases, including Bakke and Sindel and the Prop 13 case and so on and so forth. But then she left the court and went to Nepal and opened up orphanages that are still running in Nepal 40 years later. These were two fabulous, the court tends to attract characters. And this is kind of an example of the kind of characters on the staff of the justices. One of my main takeaways from the Mosk experience. I wrote 6 cases for Justice Mosk during that time. That's kind of unusual. If you look at today's annual law clerks, they will write 1 or 1.5 cases before their tenure is up and they leave. I wrote 6 calendar memos that became opinions. It was a different court with different production values and a totally different internal processing mechanism that is not quite as laborious as it is today.
Do justices, whether it be Mosk or anybody else you work with, write differently when they are in the majority as opposed to when they are in the dissent?
Oh, so this triggers kind of a fun internal joke that we had. Yes is the answer. Justice Mosk would edit, of course, the majority opinions that were produced by his staff attorneys and put his flair and style on it. The main Mosk writings, and some of his writings that are most known, were his own concurring and especially dissenting opinions. And those he wrote exclusively himself. He had very little staff involvement. We ended up calling those pro pers. They were pro per opinions written exclusively by Justice Mosk, and sometimes they were fiery, and they would circulate around the court, and it was very clear to the rest of the court and the rest of the staff that there's no way that staff was substantially involved in these particular writings. They had the ring of Justice Mosk at sometimes in his most vociferous way.
The guardrails were removed, were they?
The guardrails were removed. He did not put them on himself.
What happened after your year clerking for Mosk?
I had decided to go out into the real world and work for a little boutique law firm in San Francisco that had a fine reputation and viewed itself very highly. And I was headed there. Right as I was leaving the court, Justice Grodin approached me and basically suggested that if it came in the future that I wanted to return, that he would welcome me on his staff. That was a beautiful offer, and I really appreciated it. And Grodin's a marvelous guy. And I said, well, thank you very much, but I'm going to go out in the real world. And he said, as you should. Well, I did for 8 weeks, at which point I quit without having any job. I stayed on another 2 weeks. I want full credit. I'm not a total quitter. I gave 2 weeks notice. I called up Justice Grodin at the end of that 8-week period when I said, remember that kind of discussion and quasi offer? Any chance that that's still available? And he said, in 8 months. It was going to be September when his annuals were leaving. And so I said, fabulous. And I went and I was able to work for a Court of Appeal justice for those 8 months at the First District Court of Appeal. That was a great experience, and I really learned how the pressures and the expectations of working at the Court of Appeals vary quite different from the luxurious amount of time that we seem to have and take at the Supreme Court. And anyway, I went back to the court and worked for Justice Grodin for the next year and a half until his lease was terminated by the voters at the general election in '86.
Which I want to get to, but before we do, What was it like working for Justice Grodin?
Fabulous. It was like attending a graduate seminar almost every day. He was so thoughtful. He wanted, and here's a beautiful example of, he viewed the law as his client as well, very clearly. He wanted to get to the most natural result that fit within the contours of the law, and he was greatly respected for that by his other much more conservative colleagues, Justices Pinelli and Lucas, for example. When the election was looming, and
Jake, before you go there, let's set it up, because not all of our audience members are from California, not of them are lawyers. So give us a little background, if I may,
Sure.
if you may. What was happening politically vis-a-vis the court in 1986?
In 1986, I'll actually start in, I think, 82. In 82, Rose Bird, who had been appointed by Governor Jerry Brown to be Chief Justice, was up for a retention election. The way retention elections work in California is very strange. Some justices have to stand for them. She had to stand in 82 and then again in 86. It's the quirk of how the California Constitution works. But there was opposition to her in 82, but she managed to squeak through. In 86, it was a different situation. There were 5 justices on the ballot, Rose Bird included. And Governor Deukmejian was under considerable pressure by various groups and such to, 1, go after Rose Bird, but 2, go after as many other justices as he could. And so he set sights on both Reynoso and Grodin. Mosk was very politically savvy, managed to publish a number of death penalty affirmances in the 2 years running up to 86, and that took some of the pressure and the limelight off of him. But leading up to the 86 election, Justices Pinelli and Lucas, both appointed by Deukmejian, I understood from close contacts within the court that both of them went to the governor and actually implored him not to go after Justice Grodin. Why? Because of what I said earlier. Even though philosophically they were different from him, they appreciated his role on the court as an objective, thoughtful observer who contributed at weekly conferences and who contributed and kept the court honest, frankly, in its deliberations. Ultimately, as we know, the governor resisted those urges. He could not resist going after 3 instead of 1 and having 3 appointments and totally remaking the court, and that's what happened.
What was that like, working in the court in the days leading up to the election?
In the months leading up to the election, one had the feeling, I did, and certainly Justice Grodin did, that although this was scary and looming, we were going to squeak. He was going to squeak through. He was going to make it. That didn't change. That was the feeling until right toward the end, when all of a sudden it kind of became apparent, and I think there might have been a couple polls that came out that showed great public interest in throwing out all 3 of the targeted justices. How did that feel within the court? We continued to do our job, frankly. Justice Kaus referred to this kind of a problem as a crocodile in the bathtub. Kaus's analogy was you can stand there shaving in the morning and you can try to distance yourself or from the realities of the world and the pressure that's on the court. But it's like shaving with an alligator in the bathtub right behind you. it's really hard to distance yourself from that reality. I think very much that Grodin absolutely tried to do that. He didn't change any of his votes. I don't think that most any of the other justices did either. But there was that political reality that there was this looming, massive campaign against the justices, premised on the death penalty, but it wasn't really about the death penalty. The major criticism of Byrd and some of the other associate justices really related to their decisions in business-oriented cases, and that's where the financing and funding was from. Certainly, it didn't come from private persons who were concerned with the justices' votes on death penalty cases. That was used as the wedge, but the funding, the campaign was against these justices mostly on the basis of perceived anti-business decisions.
Do you remember where you were that night when the results started coming in?
I was with Justice Grodin at the Fairmont Hotel perched out over San Francisco. Downstairs there was a ballroom that could have ended up accommodating 200 people. There were only about 5 in it. It was a sad scene, a sorry scene. I went up to his room when at about, this must have been 10:30, 11 o'clock at night. I walked into the room and there's Justice Grodin on the sofa with his wife, Janet. The kind of bluish tint from the television is illuminating their faces. He looks up at me and you know, and the TV, of course, at this point is showing the election returns, and they're ugly. And he looks up at me and he says, "Jake," he says, "it's not the end of the world." And that was so like him, because for him it wasn't the end of the world. For me, it felt like it. For him, he continued on, and we can talk about that, but he continued on with a fabulous second career, going back to Hastings to teach again and to write a marvelous book. And heck, he even went to Mongolia and helped write the Constitution in Mongolia.
Yeah, for those of us who've had the pleasure of collaborating on talking to him, he had a remarkable post-California Supreme Court tenure. Did you at some point become friends beyond him being your boss at one point?
Oh, definitely. But he was friends with so many people, but we became very good friends. While on Chambers, we had a number of. He was an avid hiker. He wrote a book on with one of his daughters on Sierra Range hiking trails and such. We had picnics and hikes on Angel Island. That was all while I was on his staff. But after he left the court, he began teaching seminars, and regular classes, but also seminars at what used to be called Hastings, is now UC San Francisco School of Law. And prior to these weekly seminars, a group of us, Beth J. and Hal Cohen and I, would meet up with Justice Grodin at a local, usually a Thai restaurant or Vietnamese in the Tenderloin, and we would go over his seminar schedule for that day and the topics that he was going to be discussing. These luncheon meetings went on for 3+ decades.
That's good.
Culminating only about a year ago. Over time, of course, they turned into Zoom meetings, and as Justice Grodin's health failed and such, and we couldn't meet regularly in person, but these became Zoom meetings. But I met with him almost weekly for 3 decades, and along with Hal and Beth as well. And it was a fabulous personal relationship.
It's exactly 40 years since the retention election of 1986.
Yeah.
What do you think the legacy of that election is?
Well, fortunately, it hasn't repeated. Is that part of the legacy? Did we learn anything? Well, I kind of doubt that that the public has learned much. The public never understood how much it lost, frankly, by turning out Justice Grodin along with Bird and Reynoso. But what is the legacy? Well, I'm just happy to say that it hasn't repeated in that form. Anyway, we've certainly seen it in other states. Iowa, I think, a number of justices were turned out after gay marriage decisions about 10 years or so ago, and so it's happened here and there throughout the rest of the country, but fortunately not in California.
Post 1986, post that election, from your vantage point, was there more of the court collectively sticking its proverbial finger to check the political winds before issuing decisions? Was there any of that you noticed compared to what happened before?
I really don't think so. I think that the new justices who came in, the three who were appointed in early 1987, they had their own philosophies and judicial approaches. And were they putting up their fingers to check the wind? No, I think they knew where their approaches and philosophies would take them potentially differently from those who they replaced, and they simply acted on those. I don't know if I view that as reading the wind and doing the public and taking a poll and voting accordingly.
You mentioned former Chief Justice Rose Gold. I know you didn't work for her directly, but you were in the courthouse for many years with her. What was she like?
I think she was, first of all, I'll say this. I think that she was subjected to misogynist attacks and challenges and such, and that was very unfair. I also think that her personality, though, got in the way of her being a much more effective justice than she ended up being. From the very beginning, she was unwelcome at the court by Justice Mosk. He went to her and basically said, I don't blame you for being here, but I blame the governor for putting you here. That was evidently his welcoming statement to her at the court. Well, you can imagine her reaction to that might have been not all that welcoming. That was not a welcoming reaction, right? But her own personality was difficult. She had a kind of a very skeptical and paranoid approach, and she kept everything quite close. And I can give a couple examples.
Sure, please.
Stories like that. One, it was traditional at the end of each term, the annual law clerks would put on a lunch for the entire court, all of the justices and all the staff. And it fell to me to do this at the end of our term. And I very carefully picked a nearby Indian restaurant. Indian because I knew that she was vegetarian and there would be vegetarian options and such at the Opera Plaza. And I had a sign-up list, and I needed to get back to the restaurant. How many people are coming, and so on and so forth. We needed that to submit that at a certain date. I still have the list in my files, and it has like 53 names on it, and then the last 6 or so names are all from Chief Justice Byrd's staff. Why? Well, they weren't authorized to attend this lunch, and she was not indicating whether she would attend either until the very last minute. She maintained that kind of very strict control over her own staff. And it's kind of sheepishly, finally, number 54 on that list, it came into my office and said, well, I'm now authorized to sign up, and then the rest of them came in. But that struck me as kind of an example of her kind of strange controlling approach. She also tended to, here and there, alienate her natural friends. If you voted against her, if a justice voted against her view in a particular case, she had real trouble forgetting that when the next case came around. She tended to really quite remember that, and I wouldn't say hold a grudge, but it was close to that. And you just can't do that on a seven-member court where you're going to have disagreements periodically over the course of weeks and months and the year. One other little story.
Yeah, please.
One of the cases I was working on for Justice Mosk during that term had to do with a antitrust challenge to Berkeley's rent control law. And I was very pleased that I was working on such a case because I'd actually taken
Some things never change.
And so in working this up, we realized at a certain point that there was a pro tem needed to be assigned in this case because there was either a recusal or a vacancy. It might have been a vacancy.
Can you explain to the audience what a pro tem is, just for a second?
Sure. A pro tem judge is a judge who is appointed by the Chief Justice to the Supreme Court to sit on a case when a regular sitting justice of the Supreme Court, either by vacancy or recusal, isn't sitting on the case. So normally there are 7 justices on the court, but for this particular case, there were only 6. Because like I said, there was either a vacancy or a recusal. And so here I am working with Justice Mosk on this very kind of technical antitrust challenge to Berkeley's rent control law. And we were rolling up our sleeves and deep into this case, and it was intriguing and interesting and such. I mentioned to one of Chief Justice Byrd's staff attorneys, this is the Chief Justice might want to consider when she's appointing a pro tem, maybe an appellate justice who has at least some level of sophisticated experience in these cases. Why was I saying that? In the first place, Byrd was greatly criticized, and it changed as soon as Lucas came into office, but she tended to cherry pick when making these pro tem assignments. And she would appoint not Court of Appeal justices to these cases, but Superior Court justices and judges, and also municipal court judges. And indeed, she was appointing municipal court judges regularly to these cases. So here, it was kind of a cheeky thing for an annual law clerk to do, but I thought I had a good relationship with this staff attorney, and I kind of tried to gently suggest, you might want to mention to the chief that this is a very complex antitrust case, and maybe a Court of Appeal justice would be a better pro tem than a municipal court judge. And so 4 days later, her staff attorney returns to my office, and he said, the chief's response is that when Jake is Chief Justice, he can make those decisions. Totally inappropriate on her part. It was cheeky of me to suggest otherwise. And I think she was really sensitive to her appointment process, because she was being criticized at the bench in the bar for basically the charge was she was cherry picking the way she put these muni and trial court judges on as pro tems.
Was it unusual in your 4 decades on the Supreme Court for, to use your term, cherry pick lower court judges, or was it just the extent to which she did it that was unusual?
It had never been done before. She was the first Chief Justice to appoint as pro tem justices anybody other than a Court of Appeal judge. The Chief Justice before her, Wright, Donald Wright, appointed exclusively, I think, administrative presiding judges of the Courts of Appeal. So even a higher stratum at the Court of Appeal. Her view was to equalize it, democratize it, and there is some understanding about trying to spread things around and such. But according to her critics, and there might have been something to it, the lower court judges that she picked always tended to be people who voted along with her in that case in the first place. So effectively, she ended up having 2 votes on those cases. And that was the criticism. And I think she was quite sensitive to it for good reason.
So one of the few things you didn't accomplish in the Supreme Court of California, you didn't actually become the Chief Justice or even a justice at all. Did you ever consider becoming a judge?
Here and there, but I would have been a terrible trial court judge. There's no way that I would feel comfortable ruling extemporaneously on evidentiary rulings. I think I would get flustered and such. I think I appreciate the again, I'm going to use the word luxury of sitting back and thinking. I could have been a Court of Appeal judge. That would have fit. I never applied, and I never thought seriously about doing that. One of the reasons, frankly, is various governors, and for good reason, were quite interested in appointing underrepresented folks to the appellate courts. And being a white pasty guy here, that was probably not in the cards for me. Did that concern me or give me chagrin? No, not really. I loved my job with working within the court.
So back to 1986, your justice and friend is elected out. What happens next?
So I was, well, here's another Rosebud story. Right before Grodin was terminated, he had tried to put me in a higher position on his staff. I was still at a law clerk salary position, and he tried to bump me up to a permanent staff attorney position. Chief Justice Byrd vetoed that when he went to her and tried to get me that advancement. Why? Well, because I was connected to Justice Mosk. That was why. Anyway, because of that, I knew even back when I was working on Grodin that I had a ceiling. I had no possible way of advancement within the court as long as I stayed on his staff. So even before the general election of 1986, I looked around and I made arrangements to work on another staff. And Justice Lucas, who was then an associate justice, but who everybody at that point thought was going to become the Chief Justice, he and his staff indicated interest that I should join their staff. And so that was actually worked out before the results of the retention election came about. Because, like I said, I had been stymied from advancement on the Grodin staff. But that also reflects on Lucas, I think, in a really positive light. He was willing to accept onto his staff someone who had worked not only for Justice Mosk, quite a liberal lion, and Justice Grodin, a very thoughtful and objective liberal. He was willing to have me join his staff, and apparently had no compunctions about that. I think that reflects, like I said, really well on him, and basically it also reflects the ethos of the court at the time, and I think now as well, that the justices are and have been not only willing, but looking for objective, speaking truth to power type work by their staff. They would rather hear from their own staff what the problems are with analyzing a certain thing in a certain fashion, rather than having it exposed out in the halls of the court. And so better to test it within chambers than otherwise.
What was it like working for him once you joined his staff?
He had a great sardonic sense of humor. He looked like a chief justice too, kind of a central casting type thing. The chief justice has a larger staff than the associate justices. The associate justices at the time had 2 annuals and 3 permanent attorneys and secretarial staff as well. Chief justice had a total of 8 attorneys. So it was a larger staff. It's more structured and such, and you had all of a sudden much more in the way of administrative responsibilities that kind of come along with the chief justice, and the chief justice obviously needs to work with his or her staff to help administer the court. So all of a sudden, I went from doing a lot of pure law to doing a combination of law and internal management, administrative things, and that continued, of course, for decades with the ensuing chiefs.
Next on this amazing list was Chief Justice Ronald George. How did that come about?
Again, and this is kind of the way it happens in the court, you're kind of just tapped on the shoulder. He came on as an associate justice in 91 and then became chief in 96. And so shortly before he became chief, either he or maybe Hal Cohen, who was his chief of staff at the time, came to me and asked if I would be interested in joining his chambers. And of course, I absolutely was.
Chief Justice George has a reputation in many circles as someone who was incredibly politically savvy and successful. Was that the feeling working shoulder to shoulder with him? How did that manifest itself, if so?
Yeah, very, very savvy and plugged in that way. I remember Hal and Beth and I sometimes, after leaving a meeting with him in his chambers, saying to ourselves, this guy could be president. He really had that aura and that command and seemingly just broad connections and connections in Sacramento at the legislative level, at the executive level, et cetera, et cetera. One had the feeling he was extremely plugged in. Any
stories about your time working for him?
Yeah, where to start? There were a number. Well, I'll tell you 2 stories. One, I have to go back to Grodin again because it's kind of a similar story. Grodin was kind of an absent-minded professor. He was in the clouds very often, and we would walk around the Tenderloin talking about cases, just him and myself. And we were, at this point, we were talking about this. This was a San Jose rent control case, and that eventually went to the U.S. Supreme Court. And we were in depth, and we had done quite a circuit around the Tenderloin, and we're coming right back to the court, and we were at the corner of Polk, of Larkin and Golden Gate, and we were about to walk back into the building, and he stepped right into the street, right as a car came rushing by, and I put out my hand, and his chest hit my hand, and he didn't skip a beat. he was still talking about the case. And I said, Judge, do you realize I just saved your life? And he said, oh, yes. Thank you. And he went on. So fast forward 10 or so years, on the other side of that same street, at the corner of Golden Gate and maybe this was Larkin, Chief George and I were walking around the neighborhood also talking about a case. Maybe we were going to some lunch down the street at Opera Plaza or something. Some skateboarder came rushing by and almost ran us both over. I can't remember the details, but it was a close call, frankly. Somehow that ended up in some Leah Garchik column. She was a gossip writer for the San Francisco Chronicle, and she made a whole story about that.
Memo to file for any member of our audience. Next time you're planning on taking a walk with Jake Deere, make sure your health insurance is fully paid for.
Watch out.
Yes. And then you walked for your third Chief Justice in a row.
Yeah.
Tell us about how that came about.
Tani Cantil-Sakauye. It was really quite an interesting thing. She was the year behind me in law school. She was in my wife's law school class, and I knew her, vaguely in law school. I remember Chief Justice George about 5 or 6 months before he actually announced his retirement. He walked into my office one day, and all of a sudden started talking to me about this justice on the CA3, Tani Cantil-Sakauye, who he had put on the Judicial Council 2 years or so previously, and how impressed he was with her. And it occurred to me that I hadn't been in contact with her for quite a while, so a little light bulb goes off. And soon after he left my office, I sent her an email, and I said, it's been a while. Congratulations, belated congratulations to your appointment to the CA3, and I'm hearing great things about you from the current chief. Anyway, so fast forward, when when George announced his retirement, shortly after that, the governor asked him to come to Sacramento to recommend replacements. And so George he gave me a list of 4 names. They were all CA justices, Court of Appeal justices, that had been appointed by Governor Schwarzenegger. I said Duke Majan, I think just now. I meant to say Schwarzenegger. And so he had me quick little bios on each one, and he put them in his little file and went off to Sacramento and presented and proceeded to have a meeting with Schwarzenegger and his head of staff, what's her name? Kennedy, and Ann Monsantos, I think, who was the finance director or something at the time, and just George. So it's just the 4 of them in the room. And Schwarzenegger says to George, well, who do you recommend? And George had these 4 names, and he was preparing to list them out in order, but they didn't get past the first one, evidently, and that was I call her Chief Tani now. And so George extolled the virtues of Tani Cantil-Sakauye. And the story that I heard from George is that Schwarzenegger turned to Kennedy and Monsantos and said, sounds good to me, what do you think? And they didn't object. And so Schwarzenegger says, well, should we call her now? And he did.
If timing in life is everything, the timing of her appointment from what she had to do in short order was rather unfortunate. Severe budget cuts and so on. Can you talk a little about that and what it felt like from the inside of the California Supreme Court as all of this was going on?
Yeah, in the closing year and months of the George tenure, there had been quite a bit of there was animosity that was coming his way from a group that styled or called themselves the Alliance, California Alliance of Judges, or some term like that. A murky group. There was never any list of names, but there were a few names that were surfacing regularly. Most, I think, were from Southern California. George was under lots of pressure from this group. They were undermining his authority, basically, and his policies. He would go to Sacramento and lobby for this or that, and the Alliance group of judges would come in right after and undermine him and argue for something that was more suited to their needs. Also, there was at that point a kind of a computer. There was an attempt to have a statewide computer system that would amalgamate and consolidate all kinds of judicial branch information, and that system blew up, as many computer efforts tend to. George was under a lot of pressure from both of those, because of both of those things, and that's what Chief Tani Cantil-Sakauye inherited. Her first couple years were consumed by just kind of a continuation of those objections that were coming in to George, now on her shoulders. She also faced, again, like Rose Bird, some real overt misogynistic criticisms. There were overt criticisms or statements to the effect, well, she looks nice, but she doesn't have the gravitas. Well, she proved that she really did have the gravitas. And she proved that to people just slowly and over time. But over the course of her tenure, and certainly after 2 years, she could walk into a room and she commanded the room. It didn't hurt that she was also a fabulous extemporaneous speaker. She never used notes. Her major in college was rhetoric, and I think that stood her really well. She was so capable of articulately expounding on a moment's notice and on vast variety of subjects affecting the entire judicial branch, and that slowly but surely became noticed, and the critics eventually kind of slithered away.
I think from an outsider's perspective, even her critics would have to acknowledge that she left the branch in much better shape than she found it. Would you agree? And
absolutely, and it wasn't easy. The pandemic was just a huge lift. Getting not only the Supreme Court but the trial courts, especially, through the pandemic. And I remember sitting here on these computers at my desk, at my home desk station here, working on emergency orders that she was issuing, it seemed, once a week to adjust and keep the trial courts as open as possible. That was a heavy lift, and she was up to it. I think that she might have even been contemplating stepping down or prior to that, but then she realized that she just couldn't. She had to stay on during that period, and it was an arduous time and beautifully accomplished, I think.
Over 40 years in the California Supreme Court, all cases in front of that court are important, certainly to the litigants. But are there any cases that you know that when they're accepted for hearing and decision, that the court as a whole has a sense that this is really important, that history is looking over your shoulder in terms of what happens with this particular decision? Are the cases like that stick out in your mind?
They're few and far between. The gay marriage, the third in the series of gay marriage decisions was certainly one of those, authored by Chief Justice George, of course, and drawing greatly from Perez versus Sharp, Justice Trainer's 1948 decision outlawing declaring unconstitutional California's anti-miscegenation statute. But I think those kinds of monumental cases are rare. Unfortunately, I think today's docket in particular, if you look back at the court's docket 30 or 40 years ago, there were fascinating and interesting tort cases and premises liability cases and so on and so forth. What do we see on the court's docket today? We see a whole bunch of criminal cases. What's happened? Part of it, I think, is frankly ADR, what you participate in and what my wife at the other end of this house is participating in. She does lots of work for arbitrators and writes up arbitration awards regularly. But private arbitration has siphoned off a massive amount of material, and I'm using material intentionally here, that would otherwise filter up through the natural appellate system, through the courts of appeal to the Supreme Court, and become either Court of Appeal published opinions setting the law and articulating how a statute is to be construed, et cetera, or a Supreme Court opinion. Those aren't occurring at the same level of frequency as in prior years, and it's greatly, I think, to the detriment of our system. And I've talked with various folks about what can possibly be done about that, and no solution has come up yet. But it's fascinating, the kind of work that arbitrators need in order for the building blocks for an arbitration award is basically published opinions by the Court of Appeal and the Supreme Court. Well, arbitration is, like I said, siphoning off that material, and those cases are not working their way through the system, and more often, and my wife tells me this here and there quite frequently, she's working on issues that are matters of first impression. They shouldn't be. But she and the arbitrators that she works with have to make their best guess as to how this should come out as a matter of first impression. And of course, it's a secret decision. It doesn't contribute to the ongoing development of the law, and we've lost that.
One of the things that we're very good at Judicate West is we mediate cases. Cases don't make it up because the cases go away because the parties find peace and move on. And that's, I think, also part of the overall picture of why less cases are winding their way up. Any thoughts about that?
Well, just back to what I'm saying, though. Who can argue against mediation, right? I mean, parties should have suits that are resolved. But business cases and contracts that could contribute to the development of business law and such are not happening in the public sphere. And I think there is a loss that ensues from that. The California Supreme Court these days are taking public cases, cases that arise up through the ballot, challenges to ballot measures and such. Of course, there's no way those are ever going to be arbitrated. Those are public cases, and they're going to come up through the system. The other main category of cases that the California Supreme Court faces these days are criminal cases. Those aren't going to be arbitrated and mediated either. But I think it's sad that a substantial portion of what used to be the court's docket is not happening anymore and is being siphoned off elsewhere.
What does a chief supervising attorney do? That's been your title for until you retired for the last stretch of your career. What does your actual day-to-day, month-to-month responsibility look like?
Yeah. Well, it amounted to doing only about 20% of what I really loved doing, which was the law and working on review granted cases, working up a calendar memo and working up an opinion. And it amounted to a combination of internal administrative matters and, frankly, in internal personnel matters as well. But on the administrative side, I developed about 35 years or so ago, whenever an internal policy question came up, there would be a number of people around the court where you might go down to so-and-so's office and say, you know, I think you worked on this kind of, we have this internal question, how we're going to handle something internally. You worked on a memo on that a few years ago. Do you still have that file? And it occurred to me at a certain point that I should go around to all of the staff and collect these files and put them into a master file, a kind of like an internal Witkin of procedure of the California Supreme Court. And that became what is known today as the court's internal policy documents. And it's literally hundreds and hundreds of documents. And now, over time, of course, we made it electronic, and it's all available electronically to all staff and justices of the court. So that was one of my various administrative responsibilities, was trying to bring some semblance of order and consistency so that we weren't reinventing the wheel every 5 years or so with regard to internal procedural questions. And when I say procedural, there were also major substantive components to it as well. I mean, how do we handle this kind of an issue? Here are 5 examples of prior memos where we've dealt with this or a similar issue. So that's one of the main administrative things that I managed to accomplish.
You have had occasion to edit some of my writing, for which, again, I apologize. You are as good an editor as I've ever worked with. So I want you to own this. And for the rest of us who, for part of what we do is write for a living or write to make a point, or writing is important to us, as a supremely capable editor, what is a particular skill set or habits or attitude that makes for a good editor?
What I'm looking for in editing is flow, and how words flow from one to the other, and how sentences flow from one to the other, and how paragraphs flow. And so I don't know how helpful I can be, except that when I'm editing, that's one of my main concerns. Also, I'm looking for things that would cause me or others to glitch. Is a certain syntax or a certain word not precise enough, or is it sometimes too precise? These are all kind of somewhat intangible things. Again, I hark back to Peter Belton, who I mentioned at the beginning of our discussion. He taught and drove into me a lot of this stuff, including, I will say this, try this. You can come, I can't remember the sentence right now, but it's a regular sentence that has 7 words in it. And you can put, and be very careful about the word only. You can put the word only at 7 different parts of this sentence in front of different words, and it will have completely different meanings. Those are the kind of things that I look for in editing. I'm looking for precision and things that will prevent the reader from glitching and give the reader a nice, easy flow from one word and one sentence to the next.
The lawyer who I relied on to look at my briefs before they finally went in used to proclaim or complain maybe that I was overdrawn on a comma bank. I threw in way too many commas because when in doubt, why not? And there's actually a reason not to.
Yeah. I tend to not use commas as much as some other people would.
Yeah. Between the two of us, maybe there's a sane middle. In all your tenure on the California Supreme Court, did you ever find yourself working on an opinion whose bottom line decision you strongly disagreed with?
When it comes to I'm going to distinguish and put into two different buckets here: review granted cases and capital cases. Capital cases, I almost always disagreed with. I'm not in favor of the death penalty. If it was on the ballot, I would vote against it. I would love to see it abolished. I think that it's an embarrassment. If you look at the countries of the world that have the death penalty, we're not in good company. But I have to put that aside, and that's what all of the justices and the staff who work at the court ultimately have to do as well. With regard to review granted cases, do I have any that's kind of stuck in my craw and that I worked on but I didn't believe in? I can think of maybe only one out of the entire 40 years.
And do you feel comfortable talking about it?
Not particularly that one. No.
Okay. All good. We've touched about this a little, but this fascinates me. You worked for a variety of incredibly able but very different personalities and judicial temperaments and approaches in your 40 years in the Supreme Court. How do you adapt your approach? Because at the end of the day, it's not your opinion, it's the court's opinion, or it's the dissenting justice opinion. It's not yours. How do you adapt to the different styles and approaches of the people, the justices that you have worked with?
Yeah. Generally, I continue the approach that I was taught back again by Peter Belton. I continue to simply use throughout my entire tenure at the court. Every once in a while, various justices that I would work with would have maybe some syntactical or language quirks that I would have to learn to adapt to. Certainly, Chief Justice George had a certain way of phrasing of syntax that didn't always totally jibe with mine, and I had to learn how to. I learned to do that simply to save him time, and so that he didn't have to undo and put it into his parlance. But these are minor. These are minor syntactical things. These weren't really big. These weren't substantive disagreements or conflicts that I had with any of the justices that I worked for. Everybody has their own syntactical glitches. Justice Werdegar, I'll remember, she doesn't like the word that. Yeah, I found the word that is kind of helpful here and there, but sometimes so on and so forth.
Maybe that's debatable.
Yeah.
What, in your view, are the hallmarks of a good California Supreme Court opinion?
So I could probably be criticized for this because a lot of people like the idea of a short, snappy opinion that should be extremely easy digestible and would maybe be 20 pages long. I'm guilty of going in the other direction. My opinions tended to be longer. There were lots of footnotes, so on and so forth. I guess I was voting with my feet by writing them that way. The judges that I worked for accepted them. Every once in a while, they would want some things pared down. But I think that the hallmark of a good California Supreme Court opinion, and if you compare it with opinions from various other states, I did a study once that compared California's opinions with, and to the extent to which they were followed by other jurisdictions. And one of the hallmarks I think that we found is that a good California Supreme Court opinion starts out with hopefully a clear overview, but has an extensive discussion that lays out all the cards, and an analysis section that shows the math, shows how we get to the decision, not just an announcement of the decision, but shows that we considered this and that doesn't work for that reason, and we considered that and that doesn't work for this reason, and this is how we come out for these reasons. That's, I think, what a good California Supreme Court opinion does, and most of them are written in that fashion, and I think to the credit of the court.
And to its reputation.
Yeah.
Does a unanimous opinion necessarily mean that the justices had little disagreement in deciding to sign on, or could it mean exactly the opposite?
I used to have major disputes with Professor Jerry Ullman about this. He would write articles on the California Supreme Court Review on a regular basis, and he would lament the absence of a sufficient number of dissents. In his view, unless he was seeing a high number of dissents, that suggested that the justices were lemmings, just marching along in lockstep and not bothering to disagree with each other. And I tried to explain to him a number of times, and I'll say it again here, that is quite the opposite of the truth. A unanimous opinion is much more difficult to come by than a fractured decision. This is a group of 7 constitutional officers who are independent-minded and smart folks and not afraid to voice their own views. And if you can ultimately get all 7 of them to sign on to something, or even 6-1, without writing separately to get into this or that, that is a major undertaking, and it takes a lot of work behind the scenes that no one really sees. People see a unanimous opinion, and it's very easy to conclude that that was arrived at easy. It's a snap. Look how it reads. How could you possibly think otherwise? And people don't oftentimes folks don't understand or appreciate the incredible work that goes into achieving that.
Fascinating. Part of our chat today has certainly been looking back, but as you and I discussed, we also want to look forward. And looking forward for you, you're facing some choppy waters, and we agreed before you came on that you wanted to address it. So tell us what's going on.
Yeah. A month ago, I went to doctors complaining about digestive issues, and I was diagnosed, very surprisingly, with stage 4 inoperable pancreatic cancer. I'm going to enter hospice next week. So my horizon is very short. I'm thinking, you suggested that we do these interviews about 2 months ago. And at that time, I said, I'm really busy. I'm working on these projects. I'm working on this. I'm on the Marin County Civil Grand Jury. I'm working on a big project, and I've got various pots on the stove. This recent stunning diagnosis has kind of it puts a different perspective on things. I'm thinking of writing a poem, and the gist of it would be things I know because of my diagnosis, and things I'll never understand or see or experience because of this diagnosis. It's really strange to have all of a sudden such a limited horizon. We're getting great support. We have great families and friends network.
And without getting into detail that I won't, for those of us who have seen at least part of your path in the last couple of weeks and months, you've dealt with it with supreme grace and courage. When I first approached you about this, and when I developed and my colleagues developed a concept for the Profiles in Excellence, I came up with a list of 14 people that I wanted to interview, and you were there. And when I first on that list way back when,
yeah.
And when I came to you, you said, "Well, I don't think I'm worthy," and
Well, it was the excellence part that got me.
You know what? I stand by it, and and an hour and a half or so into our chat, I even more so stand by it, and I think anybody who knows you will stand by it. So in looking forward, and you've touched on some of this, but I know the other things there. How has the court culture, values, traditions changed over your tenure, and what do you hope for in the years to come?
Yeah. Well, I've touched on that a little bit when I talked about how the court was not a satellite court, and unfortunately it has become a satellite court. The values and traditions are strained by that change simply because people aren't together and in the same building and communicating extemporaneously together on a regular basis. So that's a challenge. Hopefully, though, things change, right? And so nothing is static, and I think that there continues to be, and I see it, an ethos in the California Supreme Court of people who came in like me and who are carrying on. I'll tell you specifically what I mean by that. On each one of the current justices' chambers right now, there are people who are permanent members of the court who didn't start out as permanent members of the court, who started out just like me as an annual, who went out into practice, most of them for longer than I did, and then came back to the court. And some, I just heard this yesterday from one of Justice Kruger's annuals, and it warmed my heart. She's been asked by Justice Kruger to stay on, and not as an annual, but to stay on, as I understand, as a staff attorney at the court. I'm thinking right now of 3 members of Justice Kruger's staff who are in that same category, who are working on other staffs right now. That kind of tradition, I think, and culture, to the extent it can continue, it was my path, and I'm seeing it continue. I find that to be heartwarming and a good sign for the court.
A two-pronged question, if I may. Are you looking forward? Are you optimistic or pessimistic about the California Supreme Court? And the same question about the state of justice in our country.
I'm more optimistic about the future of the California Supreme Court itself as an institution than I am generally about the state of justice in this country. I have some faith, I think, that the federal courts will remain and maintain guardrails, but the pressures are incredible. And what we're seeing happening, part of justice in this country is the executive branch, and by that I'm talking about the Attorney General, Attorney General's office. The strains and the stresses there on the federal level are frightening. Whether courts, and it's going to be mostly federal courts in that realm, can continue to play the role that they should be playing, it's not a foregone conclusion to me.
What leads you to be optimistic about the future role of the California Supreme Court? It's part of the same society that's being impacted by some of the things you mentioned. Yeah,
it is. It's not as directly impacted by the vendetta moves and the pressure we're seeing at the federal system. It's a little bit insulated from that, but there are those pressures, and there will be those pressures. I guess I have some, just from my personal experience with the court, I have, and the personnel and the current justices of the court, I have faith that they will continue the good work of objective judging and be able to stand up to these pressures. Maybe it's a little parochial, but I think I have a little bit more faith in the state system than I do in the federal at this point. And I'm hoping that I'm misguided and that the federal system will be able to stand up.
To know Jake Deere, even in passing, is to know that in no particular order, you love wine, travel, history, and a limited use of the comma in an English sentence.
Oh, and an appropriate use of the word only in a sentence as well.
right. And you go back and forth about that. But on the wine, travel, and history part of it, it has so enriched your life. Tell us a little about that.
Well, mostly we travel to France, and when I say France, I mean France. When we talk to taxi drivers in France and they ask us where we've been, we give them a list and they say, "I've never been there. I've never been there." So all over the country. But what I love is getting out of our own skin and getting out of our own culture and living in, and it's easy for us. We haven't traveled to Asia. I would love to, but it's not in the cards now. But we speak a modicum of French. What I love through travel is experiencing other cultures and understanding and realizing that there are different ways of doing the same thing or similar things, and many of the ways of what we've seen throughout Western Europe are darn good, effective ways of accomplishing things, and we can learn a lot. I think it's unfortunate that so few Americans have passports and don't experience this kind of enlightenment, I guess, really, and education about how beautifully things can be done in other countries. And in France and Italy in particular, there is a love and a zest for life. People don't structure their lives around their work as much as Americans do, but instead, mandatory vacations, and by golly, they take them and they enjoy them. We've embraced a lot of that. I've worked hard, but we've also embraced the travel. My wife and I have traveled to Western Europe 43 times in the last 35 years. We don't feel that we've missed out.
Is it to the point where you come in to Charles de Gaulle Airport and they already wave you in because they already know you from the last time?
Not quite, but not quite. And frankly, just as an aside, I love driving around, especially with a manual transmission car. I love driving around in the back roads of Italy and Switzerland and France and Germany. That's joy for me, and traveling from one lovely little hotel to another. Always a hotel that has a fine restaurant. So we check into the hotel for 3 nights, and that's our base for 3 nights, and explore and walk around. It's been great.
This has been a remarkable and I think memorable hour and 45 minutes, and our time is almost up. Before I let you go, what do you hope your legacy will be?
Well, I think maybe I just kind of alluded to it 5 minutes or so ago when I mentioned one of Justice Kruger's annuals telling me the other day that she was staying on. I like the idea of that happening within the culture of the court and kind of a continuing pollination. And the move from someone being an annual law clerk to a full-time professional staff attorney in the court, I think if I've contributed somewhat to that ongoing tradition within the court, I'm very pleased with that small contribution.
I think I speak for many who know you and even many more who don't know you, but who have benefited from your 40 years in the Supreme Court, that legacy is secure, and there's so much more about your legacy that is also secure, including your abiding zest for life. Thank you, Jake. This has been a remarkable, memorable episode. I'm sure our audience will feel the same. We will see you all, everyone, next time at Judicate West, Results Beyond Dispute, Profiles in Excellence.
Thanks, Dan. It's really been a pleasure.
Thank you for listening to Results Beyond Dispute from Judicate West. Views and opinions expressed by the host and guests are their own and do not necessarily reflect those of the organizations with whom they are affiliated or of Judicate West. Until next time.